Let me tell you about a woman who got so thoroughly screwed by a car dealership that she ended up legally owning their name. Not their car, not their lot, their name. The words on their building. The brand on every ad, every contract, every billboard. She owned it, and they had to pay her a lot just to get it back. But here's the thing. She didn't hack anything. She didn't have some army of lawyers. She found a single piece of paper, one public filing, that the dealership forgot to renew, and she used it to hold a multi-million-dollar company hostage. This is the story of Megan Caldwell, and if you've ever felt completely powerless against a corporation that wouldn't even give you the dignity of a phone call back, stay with me, because what Megan did, it's the most satisfying act of revenge I've ever come across. Megan Caldwell was 34 and ran a small interior staging business outside of Charlotte, North Carolina. You know, when someone's selling a house, Megan's team comes in, arranges furniture, makes the place look like a magazine cover. Good business, steady income. Not getting rich money, but solid. And the engine of that entire operation, literally, was her SUV, a 2-year-old Chevy Traverse. She'd bought it outright, paid in full, from a dealership called Prestige Auto Group. Huge operation. 4 locations. You've seen dealerships like this, the kind with the inflatable gorillas and the radio ads where some guy screams about 0% financing. Megan paid cash, walked in, wrote a check, got the title. Done. Or so she thought. 7 months after the purchase, Megan walked out of a client's house in a suburb south of Charlotte, and her car was gone. Not stolen, not towed by the city. Repossessed. There was a repo notice tucked into the curb where her front tire had been. She called the repo company. They told her the order came from Prestige Auto Group's financing arm. According to their system, Megan had an outstanding loan on the vehicle, a loan she had never taken out, and she was 4 months delinquent. Let me say that again. She paid cash, in full, and they repossessed her car for a loan that didn't exist. Now, here's where it gets ugly. And here's where you'll start to feel your blood pressure climb.
Megan called Prestige Auto Group, got transferred 6 times. Finally reached someone in their finance department, a man named Todd, who told her, and I'm paraphrasing here, "Ma'am, our system shows an active loan. Until that's resolved, the vehicle stays in our possession." Megan sent them the canceled check. She sent the receipt. She sent the title, which was in her name, free and clear. Todd said he'd escalate it. A week went by. Nothing. She called again. Todd was unavailable. She got someone named Brenda. Brenda had no record of the previous conversation. Megan sent everything again. Brenda said she'd look into it. Another week. Nothing. Megan drove to the dealership, in a rental she was paying $140 a day for, by the way, and asked to speak to a manager. She was told no managers were available. She sat in the lobby for 4 hours. Eventually, a security guard asked her to leave. Let me paint this picture clearly. Megan Caldwell, a woman who paid cash for a vehicle, was now out the car, paying for a rental out of pocket, missing client appointments, watching her business slide, and couldn't get a single human being at this dealership to acknowledge that a clerical error had destroyed her life. She hired a lawyer, a local attorney named Craig Bowers. Craig sent a demand letter. Prestige Auto Group's legal department responded, 3 weeks later, with a form letter that essentially said, "We are reviewing the matter and will respond in due course." Due course. That's what they said to a woman whose livelihood was evaporating. Craig told Megan the truth. They could sue, but Prestige had a legal team that got paid to make cases like hers take years. They would bury her in discovery requests, delay hearings, and bleed her dry before she ever saw a courtroom. That's how big companies win. Not by being right, by being slow. Megan was running out of money. She was running out of time. And she was furious in the way that only someone who's been completely ignored can be. But Megan Caldwell was not the kind of person who quit. She was the kind of person who stayed up until 2 in the morning reading. And what she found at 2 in the morning changed everything. Megan couldn't sleep. She was lying in bed with her laptop, and she'd gone down a rabbit hole. She was reading everything she could about Prestige Auto Group. Not their ads, not their reviews, their filings, their corporate documents, the stuff that's technically public, but nobody ever looks at. She pulled up their records with the North Carolina Secretary of State, business registration, articles of incorporation, annual reports, and then she found something that made her sit up straight. Prestige Auto Group. The name on the building, the name on the ads, the name every customer in Charlotte knew, was a DBA. A doing business as name. The actual parent corporation was registered under a different legal entity, Harmon Automotive Holdings, LLC. That was the real company. Prestige Auto Group was just the public-facing trade name. And here's where Megan's eyes went wide. The DBA registration for Prestige Auto Group had expired. 8 months ago. They hadn't renewed it. In North Carolina, a DBA registration needs to be renewed, and if it lapses, the name becomes available. Megan read that line 3 times. Then she read the relevant state statute. Then she read it again. She called Craig Bowers at 7 in the morning. Craig said, and this is a direct quote according to Megan, "Are you serious right now?" She was serious. Here's what Megan did. And it was fast, deliberate, and surgically precise. On a Tuesday morning, she filed a DBA registration with the North Carolina Secretary of State for the name Prestige Auto Group. The filing cost her $11. $11. She registered the name under her own small business entity. Legally, in the state of North Carolina, she was now the registered holder of the trade name Prestige Auto Group. Then she called Craig. Craig drafted a cease-and-desist letter, not a polite one, a scorching, footnote-heavy, case law citing, "You will comply or we will bury you," cease-and-desist letter. It said, "Our client is the registered holder of the trade name Prestige Auto Group in the state of North Carolina. Your continued use of this name on signage, advertising, contracts, financing documents, and all other materials constitutes unauthorized use of a registered trade name. Cease all use immediately or face legal action including injunctive relief and statutory damages." Craig sent it to Prestige's corporate legal team, their dealership general managers, and, because Megan wanted to make sure it landed, the CEO of Harmon Automotive Holdings personally. Megan told me later, "I wanted them to feel what I felt. I wanted them to open an envelope and realize that someone else controlled something that belonged to them, and there was nothing they could do about it with a phone call." The response was immediate, and it was panic. Within 48 hours, Megan's phone rang, not from Todd, not from Brenda, from Prestige Auto Group's outside counsel, a senior partner at a firm in Raleigh. He was polite, very polite. He said there had been a miscommunication and that they wanted to resolve all outstanding issues. Megan let Craig do the talking. Craig laid out Megan's position. She was the legal registrant of the name. Every day, Prestige continued to use it. On their website, their contracts, their building signs, their financing paperwork. They were in violation. And every contract they'd signed using that name during the lapsed period? Potentially voidable. That meant hundreds of active car loans and lease agreements were now sitting on legally questionable ground. Let me let that sink in. Hundreds of financing contracts, worth millions of dollars, could theoretically be challenged because the dealership signed them using a trade name they no longer legally held. Prestige's attorneys understood the math instantly. They came back with an offer. They'd return Megan's car, reimburse her rental costs, and pay $20,000 for the DBA transfer. Megan said no. They came back at $50,000. Megan said no. Craig sent a counter-demand, full return of the vehicle, reimbursement of every dollar Megan had lost, rental fees, missed client revenue, attorney costs, plus a licensing fee of $120,000 for the right to use the name Prestige Auto Group going forward. Or Megan would begin filing complaints with the state attorney general's office and notify Prestige's lenders that their financing contracts might be legally defective. There was silence for 4 days. Then Prestige's attorneys called back and agreed to everything. Megan got her car back. It was detailed, full tank of gas, parked in her driveway with an apologetic note from the general manager, the same dealership that had security escort her out of the lobby. She got reimbursed for every penny she'd spent. The rental, the missed jobs, Craig's fees, all of it. And she got a settlement check for $120,000 for a name she'd registered for $11. But here's the part that Megan said mattered most. It wasn't the money. She said it was the moment, during the final settlement meeting, when the CEO of Harman Automotive Holdings sat across the table from her and had to ask her permission to use his own company's name. She said he couldn't look her in the eye. She said, "For 3 months, I couldn't get anyone at that company to return a phone call. And now their CEO was sitting in a room asking me, for permission to keep the lights on. I wanted him to understand what it feels like to have something that's yours taken away because of someone else's mistake. And to have no one care." The DBA was transferred back to Harman Automotive Holdings as part of the settlement. Megan signed it over. But the deal included a clause, and Craig insisted on this, that stated if Prestige Auto Group ever again repossessed a vehicle without verified loan documentation, the DBA assignment would automatically revert to Megan. They agreed to that too. Megan Caldwell walked into that dealership as a woman who'd had her car stolen by a corporation. She walked out owning their name, their dignity, and a check for $120,000. $11. That's what it costs to remind a multi-million-dollar company that nobody is too small to fight back. If this story lit a fire in you, drop a comment and tell me. Have you ever been bulldozed by a company that wouldn't even acknowledge you existed? I want to hear it. And subscribe, because the stories on this channel only get more intense from here. I'll see you in the next one.